Masingill versus EMC Corporation.
Thank you.
Thank you.
Mr. Glasser?
Good morning. May it please the Court, George Dresser representing Joanne Masingill. My partner Roy Bourgeois is with me. This case involves fraudulent misrepresentations made by the defendants in connection with hiring the plaintiff. We have an appeal based primarily on a faulty jury instruction. There's a cross appeal from the denial of a motion for judgment notwithstanding the verdict. My intention is to focus primarily on the issues involving the jury instruction. The jury found in response to special questions that the defendant, Ronald Skates, made knowingly or recklessly misrepresentations of material fact to the plaintiff, intending that she rely on them, concerning his intention to give her what the parties refer to in this case as a full shoot, and that's shorthand for a golden parachute, referring to severance benefits that the employee would receive in the event the company was sold. Notwithstanding that finding, there was a defendant's verdict on the misrepresentation claims due to the erroneous jury instruction, which contained a misstatement of the law on reasonable reliance.
Well, these statements that you're talking about now, they were made early on in the discussions between Ms. Masingill and EMC, right?
That's right.
And then there was a negotiation.
Right.
It sounds to me, at least, and you may have a different view, it sounds like a fairly intense and thorough negotiation of the contract.
There was a fair amount of back and forth between the parties before they got to an agreement that they signed.
And so, certainly, although misstatements, the jury may have found that misstatements were made early on with the intention of her relying on them, after the negotiation and after the contract, to the extent the contract is different than those misstatements, isn't that the point? Isn't that what the judge was pointing out, that in the facts of this case you have a contract negotiated between the parties?
Well, that's right.
In those circumstances, how could there be reasonable reliance on a term when there was a term in the contract on the very point?
Well, that's exactly the point of our appeal, is that to the extent the contract did contradict these representations, Ms. Masingill had no knowledge of that.
What do you mean she had no knowledge of it?
She did not perceive it as a contradiction. And you have to go back into the evidence.
Right.
The misrepresentation was made when she asked Skates if she could have forward vesting of stock options as part of her contract in the event of the sale of the company. And his response was, no, you can't have that in your written contract because that's part of the full shoot, the golden parachute. And other employees at your level do not have that in their written contracts, and so it cannot be in your contract. However, I'll make sure that you get it. And that's.
But she sounded like a sophisticated negotiator. She had already lost out on things she wanted at her prior employer, and she was very concerned about what would happen in the event of severance. She doesn't sound like in these circumstances it would be reasonable for her to have relied on an oral representation that was contradicted by the contract because it wasn't in the contract.
That's what the
people
judge
say to you all the time, I'm going to give you this, don't worry, don't worry, don't worry. And if a person's naive, it might be reasonable for them to believe it, but it seems difficult to conceive that this type of person would rely on an oral representation that wasn't reduced to writing in view of what had just happened to her and in view of the other demands she made and got.
Part of what he said to her, though, was he explained to her that it would not be in the contract,
and the jury
it could not be in the contract.
The jury found he made it knowingly, recklessly, and it was false. They found that. You're fine. Don't argue it. What the jury also found, it wasn't reasonable for her to rely on that.
That's right, and that's because that was what they were required to find under this instruction. They were required, well, there was ample evidence of the contradiction, but the contradiction is not apparent on the face of the contract unless you know what this full shoot is.
Well, it
Because
doesn't matter what the full shoot is. It was whatever the golden parachute was, whatever it was. Forward vesting, big payout, double your pay for the year. It really didn't matter. It seemed to me what the jury was finding was that she couldn't rely on the fact that I guess he was the CEO in this instance, was saying to her, don't worry, I'll take care of you.
The contradiction is that the contract said, upon sale of the company, you will get 1 year of salary.
Right?
The full shoot, if she had got it, said you will get 3 years of salary, and you will get forward vesting of stock options.
But she
didn't know that.
She knew she wasn't getting any aspect of a golden parachute in her written...
The contract does not say that. The contract does not say you will not get a
Of course
golden
it doesn't,
parachute.
but it doesn't say you will get a golden...
That's right. It's silent on the issue of the full shoot. It's
So
silent
why,
on the
given
issue of
her
forward vesting.
situation, is it reasonable for her to rely on the oral representation in the face of a written different contract?
Because she didn't know that the contract conflicted with the representation.
She didn't read it?
She read it. It doesn't say anything about a full shoot.
Right, so then
it
she
doesn't
isn't...
say anything about forward vesting.
Right, so why should she reasonably, given how tenacious she was in her negotiations, why is it reasonable for her to have relied on an oral representation that wasn't included in the written contract?
He had told her that. He had told her it would not be in the written contract. It's like Norton Company.
I understand that he told her, but it doesn't seem in the situation that existed here, and the jury so found, that it was reasonable for her to have relied on somebody saying, oh, don't worry, I'll take care of it.
But that's a question that the jury should have
And
been
they
able
found
to
against
determine.
you. The jury found against you.
The jury didn't. The jury wasn't allowed to look at the reasonableness question. They were told to stop if you find a contradiction.
Oh, no, the judge gave them a long instruction on considering all the circumstances, whether it was reasonable for her to rely on an oral representation in face of the written one.
And he said if you find a contradiction between the contract and the representation, nobody could rely on that representation.
Was that the
Right.
same instruction given for Mr. Schwartz?
I think it was applicable probably to both of them.
Yes, so the jury obviously didn't... I mean, the jury understood... I mean, there was a, quote, flat contradiction in your terms with respect to what Mr. Schwartz had said. Am I correct?
No, I don't think there was.
But what's, I mean, I'm
Only
looking at...
with respect to Skates would they have found a contradiction.
I'm looking at the instruction, and I mean, he says several things that are obviously relevant that you object to. A reasonable person would not, could not rely on oral assurances or promises that were flatly contradictory to the provisions of the written contract. That would not be reasonable reliance. And that's all preceded by a statement that where the contract has been fully negotiated, which I take it was here. So why is that wrong?
Because it can't put her on notice of the falsity of the representation if she isn't aware of the contradiction.
Well, he goes on to say, it may be a question of fact for you to determine whether a particular oral statement or representation is indeed flatly contradicted or flatly contradicts a written contract provision. But if it does, it could not be the sort of misrepresentation that would form the basis of a claim for misrepresentation. Why aren't those two things working together? I mean, the jury could well find that the oral statement was not the oral statement of vesting, which would not be in the contract, was not flatly contradicted by the contract.
Well,
right?
I think it would be very difficult for them to find that.
Why?
Because-
He said. I
because
thought
the
you said the
contract-
evidence was. He said that you'll get vesting, but that's in a full shoot, and that won't be in your contract.
Right.
So
But the
that clearly is not inconsistent with the contract that provided a 1-year severance package for.
But the 1-year severance package is in the contract, and a 3-year severance package is in the full shoot, and that's a flat contradiction. That's not a question of the contract being silent
But
on
she
it.
knew that she knew that forward vesting of the shares was part of a golden parachute and was not in her written contract, correct? That's a flat contradiction.
I would disagree respectfully. That I would say that is not a flat contradiction. That's silence in the contract with respect to the factual representation made to her orally. The
Why
flat
isn't that a
contradiction is 1 year
contradiction?
versus
Why isn't
3
that a
years.
contradiction?
What's that?
Why isn't that a contradiction?
Because it's the
not there.
contract not saying anything. It's silence. That's not contradicting the statement that you will get a golden parachute.
Did the contract say it was the whole agreement between the parties?
That's got no integration.
No, it didn't.
clause.
There was no integration clause in there.
Well, that helps you, doesn't it?
That's right.
Well, it does. It doesn't.
But we're not suing. This isn't a contract claim.
No, I know,
We're
I
not saying
know,
it's
I know,
part of the
but-
contract.
And what do we make of this purported reassignment by the Chief Justice, then Chief Justice, to another session of the court?
Well, I think it's a very unfortunate thing to have happen from the point of view of how it's perceived. And we talk about public perception, but I think we also have to think about how it's perceived by the parties,
Well, let's
by the
suppose
litigants.
we say it is a very unfortunate thing and that public perception, wasn't good, shouldn't be good. How does that affect the result in the case, if in any way?
Well, I think if you think about how our client looks at it, I mean, if she's going to lose this case, fine. She ought to come away from it feeling that at least she had a fair shake in the judicial system.
There's nothing to suggest that she didn't have a share fake before Judge Billings, is there?
Well, I guess what I'm saying to you is you're not looking for a new trial, are you? I mean, for that reason.
Well, it was part of our new trial motion.
It is.
But what is there to show that the judge was not fair in any way, the judge that
There-
was assigned? Because, in fact, he ruled in your favor on the summary judgment motion.
That's right. And we're not saying that there is anything to show that he was subjectively biased. What we're saying is that it leaves our client feeling that, okay, the well-connected defendant was able to pull some strings in the judicial system, get a change from one judge to another, and then that judge gave what we believe was a seriously erroneous jury instruction that has had the effect.
What's the remedy? Is the remedy a fair trial, or is the remedy a string pull?
I'm sorry, I don't understand.
What do you get if you don't get if you received a fair trial? What is your remedy for this?
Well,
error?
we're saying we didn't receive a fair trial because of the jury instruction.
But not because the judge
That's
was
legal error.
biased. But not because the judge was biased or prejudiced against your client.
Yeah,
You're
the
saying
re-
the judge made an error of law,
We're
which
saying
any
the
judge
ju-
can
I
make.
agree.
Yeah,
And you have your
reassignment
remedy
law.
The
here.
reassignment to that session didn't cause the erroneous jury instruction. That's something, if it is
No,
erroneous, the judge did, and you get a new trial if it's material.
That's right. That's right. But I'm
But
talking about the
standing alone,
perception.
you've got this disagreement with the reassignment, which may or may not have been appropriately handled, but it doesn't seem directly to lead to any remedy.
In this
If we've-
particular case, it does, because if you give us a new trial on the, I don't care whether you give it to us on the jury instruction or on the recusal issue, but it will leave the perception of the litigants, of our client, at the end of this thing, win or lose, whatever the jury decides on reasonableness, if they're given a
Of
fair...
course, we don't have any factual basis to find out precisely what occurred, do we, between Judge Del Vecchio and
No, we don't. There was,
We don't.
That's
So
what we
somebody's
were
gotta
asking
do
for, was a
that.
hearing about
Mr.
it.
Glasser, was this referred to the Judicial Conduct Commission? Was there a proceeding before the Judicial
I
Conduct
don't
Commission?
believe there was.
And she's retired now, so I don't even know if the commission has, if it's appropriate for the commission, whether it has jurisdiction over a retired judge for something that occurred like this years before.
Wouldn't your remedy have been at that time or any appropriate time to have made a complaint with the Judicial Conduct Commission?
Well,
for,
that-
for what you perceived as Because you don't have anything in your briefs, at least that I can see, to support any showing of bias or prejudice or unfairness by the judge, which should have caused him to recuse himself.
No,
I understand that you've got a legal claim with respect to a jury instruction. Let us assume, only assume, that we conclude that the jury instruction was not erroneous, that the flat contradiction was not erroneous, so that your client is not entitled, assume that your client is not entitled to a new trial on that ground. Correct?
Okay.
Just assume that.
Just assume that.
Assume
Just
that, okay.
assume that.
Okay.
That surely removes any possible suggestion, and I don't believe that you've made any, that Judge Billings was somehow making rulings because of any influence, correct? You haven't made that.
We have not made that allegation.
Exactly.
We did ask for an evidentiary hearing at the time, and we believe it was error for
Well,
him
you could have come
not
up
to do
here on
that.
probably could have come on a 211.3, but, well, that's academic. Okay, thanks.
Thank you, Mr. Glasser.
Thank you.
Ms. Lukey?
May it please the Court, Joan Lukey, and with me my partner Amanda Masellam, for all defendants in this action. The substantive challenge here, as the Court knows, is of a specific part of Judge Billings' jury instruction on misrepresentation. That was a 20-page instruction giving all 6 elements of misrepresentation. On the 19th page, he got to the charge on reasonable reliance. In the second part of that charge, after talking about subjective reliance, he turned to objective or reasonable person reliance. As part of that charge, he then gave them the paragraph challenged here, which is an exact quote from Starr versus Fordham, your 1995 decision, adopting language from Turner versus Johnson & Johnson, an exact quote. If the contract was fully negotiated and voluntarily signed, plaintiff may not raise as fraudulent any prior oral assertion inconsistent with a contract provision that specifically addressed the particular point at issue, end quote.
Ms. Lukey, did the Fordham contract have an integration clause?
It's no reference in the case to an integration clause, Your Honor.
And you just don't know?
I just don't know, but actually in
Okay.
this case, we had discussion about it, and because the plaintiff had waived the contract claim, the determination was made that there was no reason to inquire into integration clauses. But in this instance, I wish to make it clear, because it is not at all clear from the plaintiff's brief, certainly, that the judge didn't tell the jury that there was a flat contradiction here. As Justice Cordy referenced, he told them it was a question of fact, or maybe a question of fact. It was up to them to decide whether the specific oral representations were flatly inconsistent with provisions in the contract. Although here, in order to make the legal argument challenging the charge, the plaintiff has contended that there was a flat contradiction. If you look to the transcript of closing arguments, you will see that while we, the defendants, argued the flat contradiction, which I'll reference again in the moment, the plaintiffs argued no flat contradiction because they said the contract was silent on the points that Mr. Skates had allegedly discussed in a get-acquainted meeting, not a meeting for negotiation of the contract, that occurred before the negotiations began with other individuals at Data General, now EMC.
I take it your argument was the flat contradiction was not the 1-year, 3-year, but whether or not she would get a golden parachute or not a golden parachute.
Well, the real issue was what was going to happen on change of control. That's what she testified had been discussed with Mr. Skates. She said that he told her that he'd consider giving her a chute later and that he would protect her in some fashion, which ended up not happening. With regard to what the contract said, however, she went on and negotiated 2 addenda to the contract originally offered to her. It's all part of Exhibit 1 in the exhibits volume. Each of the addenda dealt with what she was able to extract from the company with regard to change of control. Now, if you then contrast that with Exhibits 27 and 28, which was her proposal within 3 or 4 days of ultimately signing the contract, you find that she is specifically asking for forward vesting of her stock, and, secondly, to be treated in the same way as all other vice president and officers, which would have included corporate officers, and guaranteed her the chute. She didn't get it. Now, she was still asking for it in writing, that's Exhibits 27 and 28, within a week of signing the contract, and she knew she didn't get it. Indeed, one of her allegations against Mr. Schwartz is that he didn't go back to Mr. Skates as he promised he would in that pre-contract period and get Mr. Skates to give her the full chute. She knew she didn't have the full chute. That is our position and has consistently been our position because the contract says what she gets on change of control, says nothing about forward vesting of stock. Now, she at the time argued there is no flat contradiction here because the contract's silent on these points. If that is so, then the charge given by Judge Billings hasn't even been challenged by the plaintiff because he gave the jury an extensive charge as to what to do if they found no flat contradiction. In fact, he basically said to them, now here's all of the elements, and the only place you would deviate is if you make a finding of a flat contradiction, and he used the phrase flat contradiction 3 times, then you have to take into account the language from the Starr case, which he read them. And basically, there are 4 elements. There's a line of cases on this, which the plaintiff has tried to avoid, but there's the First Circuit Turner case, there's the Starr case, there's the, I think it's Greenery Rehabilitation Group case, which is appeals court, Mass Appeals Court. They look for 4 elements. One is, after the alleged oral statements, there is a fully negotiated, subsequently signed, voluntarily signed, written contract with specific provisions on the same point. When those 4 elements are met, then the language is as the judge gave it to them. Under those circumstances, it's your quote from the Starr case, a reasonable person cannot reasonably rely on earlier oral statements. So what the plaintiff has tried to do is take themselves out from under the Starr line of cases, which Judge Billing repeatedly in the transcript on the when the conference was occurring said this is governed by Starr, and the jury will have to make the factual predicate findings, but it will be governed by Starr. They tried to look to the Bates and McAvoy cases. In Bates, there was no subsequent written contract. There was simply a sales confirmation slip that had a general disclaimer saying any previous representations don't apply, and the court rejected that in 1941. In McAvoy, the oral representations were made at the time of the signing of the written contract to induce the signing. When the plaintiff in that case said, well, what is this termination provision in here? You can terminate my services in 60 days. The oral representation was ignore that. It's inoperative. It's not actually part of the contract. Those are a different line of cases.
Ms. Lukey, can I just turn to the Schwartz misrepresentations?
Yes.
You make a claim that making her whole was too vague to support, a finding of false representation. Could you tell me where the $37,000 comes from?
We have no idea where the $37,000 comes from. There were 3 representations that they were relying on, and unlike the case with Mr. Skates, the judge didn't separate them and no one objected in the special verdict form. So, as it happens under Abramian and other cases, if any of those 3 shouldn't have gone to the jury and we objected to any of them going to the jury, then the verdict has to be reversed. If all 3 turn out to be, in your view, legally wrong, they shouldn't have gone to the jury, then the verdict gets entered now for Mr. Schwartz. But the 3 promises were, one,
made whole, the
make her whole after 6 months.
And the guarantee an annual performance bonus.
Right.
And 37 doesn't relate to any one of those?
Well, not in any way that we could determine.
Okay.
The go-to-bat for the chute would have had a value very, very much higher than that if she's alleging that the damage was that she didn't get the golden parachute. That's the original claim in this case. I think the ad down was $2 million. So it couldn't be that. The the guaranteed year-end bonus didn't actually come out to $37,000, but it could have been something that they worked out in some fashion, because the way the contract read on that one, this is again that same issue of the Starr ruling, the contract said that she would have a target bonus of 35% of her base salary. Her base salary was $210,000, so $37,000 isn't it, but the only thing that we could figure was that they somehow said, well, it was a target, it wasn't guaranteed, in which case it shouldn't have been used as the misrepresentation basis.
What is your specific basis for claiming the JNOV should have been granted in your favor?
The specific basis is that we said that all three of the alleged misrepresentations could not legally support a claim for misrepresentation. The make whole, because it was too vague and because she actually was making more money, so there's no way to determine what make whole would mean. The go to bat, because it was raised for the first time in their opposition, oral argument opposition to our motion for directed verdict, so that there was no evidence in the record from her that she had ever relied on that representation, since it wasn't in the case at that point. And the alleged promise of a guaranteed year-end bonus, that was not possible under Starr, the same jury instruction that we've been discussing, namely that she had voluntarily entered into a negotiated contract in which what she was told was that she would have a target bonus of 35%, not that she was guaranteed a bonus. So those were the bases on which we had asked the court not to allow any of the representations to go to the jury. There are other bases in our brief, but that's the primary basis on each as to why they were legally insufficient. Any one of those three was legally insufficient to justify sending those matters to the jury. And frankly, the go-to-bat one was a particularly troubling and angering one, because it was raised in opposition to the motion for directed verdict after the plaintiff's case, and that struck us as being unfairly prejudicial. We would say as a legal matter, however, that this court should look at the fact that there is no testimony anywhere from her that she subjectively relied on a promise that he would go to bat for her.
Well, the quotation in your brief, about you don't contend that he stated the words falsely, that was only with respect to the made whole. That wasn't with respect to the go to bat.
I'm sorry, which part are you looking at in our brief, Your Honor?
Page 40. You quote from her testimony that she believed that Schwartz did not intend to mislead her when Schwartz, allegedly made the statement, and then you quote some.
That was the make whole.
That's the make whole. So
yes.
That does not apply to the go to bat.
No, actually, there was no questioning of her with regard to go to bat, because it hadn't been raised yet as one of the representations on which she was relying. Okay. So not only did we not challenge it, which is what was happening here, this was my questioning of her on cross, but the plaintiff's counsel didn't raise it. He didn't ask her whether she had relied on a representation that Mr. Schwartz would go to bat for her. That may be because the suggestion of go to bat as a representation came up in the testimony of the executive placement person, the headhunter, if you will, who said, gee, he told me he was going to go to bat for her. He denied making that statement, but admitted he didn't go to bat for her in the period before the contract was entered into.
Before the contract?
Before the contract. The allegation was that he was supposed to go to bat for her to get Ron Skates to agree to give her the full shoot. This is why I said a moment ago that her arguments are somewhat inconsistent, because she was asking Joel Schwartz if he could get Ron Skates to agree to the shoot that she now claims that he orally promised her, and then she adds the claim that he remained silent with regard, or he said the written contract would be silent on that issue. However, that would mean that there was no flat contradiction, the whole charge would apply, and the charge is not challenged, it's clearly correct, and the jury knew exactly what they were being told to do if they found the flat contradiction, which was left to them, and they knew exactly what to do if they did not find a flat contradiction when they made their determination. So here, the judge had made a point of saying to them This does not even have to be intentional deceit, so the references in the briefs to findings that Mr. Skates and Mr. Schwartz lied are very troubling to them. He said recklessness simply means in this context that they were speaking of facts that were susceptible of being known. They spoke of them as if they knew the answer, and they hadn't bothered to check the correct answer, so it is not necessary that they have intended to deceive. Those were the yes answers, and as you know, with regard to Mr. Skates, they went on to say there was no reliance to her detriment. And indeed, as Justice Cowan has pointed out, this woman was a sophisticated businesswoman for 30 years who had just come out of the same controversy at Compaq, where she contended that she had an oral promise of forward vesting and Compaq refused to honor it. Now, that had just happened within the few months preceding these events, and hence it was very understandable and supportable for the jury to conclude that she could not reasonably have relied on her interpretation of an oral contract that was flat out refused for inclusion in the written contract 3.5 weeks later.
Thank you, Ms. Lukey.
Thank you, Your Honor.